Hi, I'm Chris Wolfe of the Thomas International Center, and today we're going to go ahead with Class 5 of our short course on the goals of American government and the Declaration of Independence, part of our longer course on American constitutional principles. In previous classes, we've gone through the first four of the self-evident principles of the Declaration of Independence, that all men are created equal, that they're endowed by their Creator with certain inalienable rights. Among them are life, liberty, and the pursuit of happiness, and governments are instituted among men to secure these rights, deriving their just powers from the consent of the governed. So today we want to take up the fifth, which is the right of the people to alter or abolish government, instituting new government, establishing it upon such principles and organizing its powers in such forms as to them shall seem most likely to affect their safety and happiness. For shorthand, we'll call this the right to revolution. Now, the right to revolution is in some ways a very important principle, a necessary principle, and yet also in some ways a kind of dicey principle as well. First of all, we have to understand we're not talking here about a legal right. We're talking about a natural right. You know, natural rights in some sense transcend the legal system. Even if the legal system falls apart, we still have rights to life, liberty, and pursuit of happiness. And within a given nation or country or form of government, if you're appealing to the right to revolution, what you're saying is not that you're trying to operate within the laws, you're trying to say that that whole system is in some fundamental sense wrong or corrupt, and needs to be fundamentally transformed, and you're appealing beyond the law. You're trying to transcend the law to appeal to this natural right to alter or abolish government when it becomes tyrannical. So some people have actually, I guess, tried to, in some ways, institutionalize, at least you might say, a part of or a bit of or the initial steps of the power to alter or abolish government. One of the questions the Supreme Court has confronted in various ways in the 20th and 21st century is whether there's a right to advocate forcible overthrow of our government. And ultimately, the Supreme Court has held that there is a qualified right to do so, unless there's a really clear and present danger that action will be taken that results in some kind of serious violence. So in some sense, you might say we've kind of quasi-institutionalized a part of the right to revolution, even within our own government. I'm not sure the founders would have agreed with that, but it's an indication of the breadth of freedom of speech, a subject we'll be talking about further later on in this course. Now, let me confront a problem or a significant issue with the right to revolution. And this is a principle that isn't just a problem we can think about today abstractly. It's a very practical problem that Lincoln had to confront at the beginning of the Civil War. Lincoln said that every principle he had was derived from the Declaration of Independence. He said all hail to Jefferson and really emphasized the Declaration in his whole argument in the constitutional debates leading up to and during the Civil War. And one of the things he obviously had to grapple with was this whole question of the right to revolution. Because after all, could it not be said that the South was simply exercising its right to revolution as it had been embraced by the Declaration of Independence? Of course, Lincoln denied that that was the case. He said that it was legitimate for him as chief executive to resist the attempt of the southern states to secede. So what was his argument? How could he respond given the fact that the Declaration had embraced this right of the people to alter or abolish their form of government? Lincoln points out that if you really take this to the hilt, that every time a part of a people wants to withdraw because they're particularly unhappy with the direction of government, what you really have established is virtually a principle of anarchy, because you start off with a country and then part of them secede, and then part of them secede from them, and part of them secede, and it just goes indefinitely until you get down to the imperial me, down to a very, very small group of people perhaps, or to the lone individual. And you can't sustain government with a principle of anarchy. So how is Lincoln going to try to deal with this issue? I mean, one thing that's not open to him is to say, well, the right to revolution, the right to alter or abolish government belongs only to the whole people and not to part of it. Now, that doesn't work, obviously, for a couple of reasons. One is, think back to the original Declaration of Independence. We're talking here about the American people, in effect, seceding from the British Empire. It's only a small part of that people. They certainly don't have the permission of the rest of the empire, and yet they claim the right to revolution. So they're not in a position to tell the South, well, you can't do that because you're only a part of the people, because that would undermine the claim of the original Declaration. Moreover, Lincoln himself, when he was in Congress in the late 1840s, made a speech in which he supported the right of the Hungarians to revolt in the Revolution of 1848, despite the fact that the Hungarians were only a part of the overall Austro-Hungarian Empire. And yet he said, they had a right to revolt. When you think about it, isn't that the whole issue? It says that a people has a right to revolt, but the whole issue is, who is the people? For instance, in the Revolution, was the people the British people, or was there a separate and distinct American people? Likewise, the whole issue with the Civil War is there an American people only, or is there also a distinct, Southern Confederate people as well? And so that line of argument is not going to work. I think what Lincoln had to do was to subtly tame the right to revolution, to establish some kinds of principles that would limit it. If you look at the Declaration itself, it seems to suggest that it's simply a judgment of a part of the people themselves, whether they are a separate people and whether they can exercise the right to revolution. For example, think back to that phrase, they can institute new government, laying its foundation on such principles and organizing its powers in such forms as to them shall seem most likely to affect their safety and happiness. There's a kind of emphasis on, their particular judgment, what they think, what this group thinks. Now, of course, the South considered that it was necessary to secede. And on what ground could Lincoln come back? I think his argument was this: if we allow somebody to secede anytime for reasons that they deem sufficient, we have established this principle of anarchy. We're not going to be able to maintain government, and democracy, instead of being the hope of the world, will be shown to be a false hope. It will be something that can't work. Because obviously a lot of people get unhappy with a lot of significant public policies or laws, and if every time you're really unhappy, you have a right to secede, it's going to be very difficult to sustain the government. So Lincoln, in effect, tames the right to revolution by subtly insisting that there are certain conditions for its proper exercise. The first of those conditions is, well, first of all, we're considering a democratic form of government, such as the United States, in which there are regular elections and people have an opportunity to express their dissatisfaction by voting in elections. I mean, if you're in that kind of government, it's obviously a very different situation from being in a form of government where there is no regular opportunity to express your opinion, to express your dissatisfaction with laws and policies. I mean, obviously the right to revolution is going to have a wider scope when there's no other alternative than in a government where you really do have an opportunity to express your dissatisfaction and to try to change things. Second, Lincoln argued that if the part of the people that is unhappy with government policies and laws has a genuine case that their basic constitutional rights have been denied, that the agreement in the original Constitution has not been kept, then there's a wider scope for the exercise of the right to revolution. If the rights of these people, the constitutional rights of this particular group that's unhappy and wants to secede, have been respected, then there's less legitimacy in their exercise of the right to revolution and more legitimacy in the central government insisting on maintaining the original form of government. Because, of course, when you look at this from the standpoint not of the seceders, but of the government as a whole, in some ways, don't they too have the right to establish the form of government that seems best to them? That is to maintain this form of government that includes the whole country. And so there's a serious question here whether or not there have been any denials of fundamental constitutional rights to the South. And of course, the South and the North disagreed about that, but Lincoln's argument was that the South was wrong when it maintained that its fundamental constitutional rights had been violated. Lincoln acknowledged, if we had gone into the South and tried to eliminate slavery in the South, that would have been a violation of the Constitution. Because under the original Constitution, slavery had been left to the states, and certainly by implication in numerous parts of the Constitution, the right of the southern states to maintain slavery was maintained. You had the protection of the slave trade for a short period of time, for example, and just the fact that there's nothing in the enumerated powers of the federal government that would authorize it to go into the southern states to abolish slavery. Lincoln was even willing, on the eve of the Civil War, to support an amendment guaranteeing that the federal government could not intervene in the states in order to abolish slavery, in order to maintain the Union. Just a brief digression here. This doesn't mean that Lincoln didn't care whether or not slavery persisted in the Union. He was committed ultimately to the elimination of slavery. I talked earlier, when I talked about all men are created equal, about the fact that the founders did believe that the slaves were human beings who had natural rights and wanted to put slavery ultimately in the course of extinction. They wanted to put it on a path where it would be abolished. And you can see evidence of that in the Constitution itself. How many times is the word slave or slavery used in the Constitution? It's actually not used. Whenever they referred to the slaves, the founders used circumlocutions. They talked about 3/5 of persons of other description, or they talked about such people as the states choose to import. But they avoided the use of the word slavery because they didn't want to saddle the document with that word, because they felt that slavery was unjust. And yet, as I argued earlier, in order to maintain the Union, which they thought was so important, they were willing to make that compromise because they did think that eventually slavery would die out. Well, of course, as we know, it didn't. We discussed that earlier. So the question is, can the South say that the North has actually intervened in the South to eliminate slavery, thereby violating their rights? Of course, the North didn't try to go into the South to do that. The key issue before the Civil War was, can the federal government prevent the spread of slavery to the territories? And there Lincoln argued there was no constitutional right to slavery in the territories because Congress had the power to make laws, rules and regulations for the territories. So Congress had the power to prohibit slavery there. And he did this with a very definite goal of ultimately encouraging the elimination of slavery, because he thought that if slavery was not permitted to expand, partly for economic reasons, that would contribute to slavery eventually dying out. So Lincoln argued that no constitutional right had been denied the South. Of course, the South was worried that if more and more states entered the Union as free states, that their power, especially in the Senate, to protect themselves would be weakened. But Lincoln would have responded, but we haven't denied you any constitutional right. And in fact, he also would have argued more broadly that while we had to respect the right of slave states to maintain slavery, in the long run, it was a good thing for slavery to die out, and for the federal government to pursue that policy was perfectly consistent with the Constitution, especially as that Constitution is understood as a way of carrying out the principles of the Declaration. So, Lincoln argues that the South hasn't been denied any fundamental constitutional right, and so therefore they have that much less ground to claim that they can exercise their right to revolution. But in some ways, the question of the right to revolution is almost a kind of going back to the state of nature. Ultimately, it's going to be resolved by force if the two contending sides cannot agree on whether it is a legitimate exercise of the right to revolution to withdraw from the Union. So the founders did think you could exercise the right to revolution under some circumstances, but they also did subtly indicate that there were some conditions or limits on the exercise of the right to revolution. And they saw that as necessary, I think, to preventing the idea of the right to revolution from becoming just out and out a principle of anarchy. Interestingly, when you think about the founders and the right to revolution, one thing that should occur to you is that revolutions aren't always bloody. That sometimes the right to revolution can be exercised in a bloodless way. And perhaps the best example of all is actually going to be the Constitution itself. Remember that, well, not remember, we haven't talked about it yet, but we will sometime soon, that we had originally the Declaration of Independence, then we adopted the Articles of Confederation, and then eventually those were felt to be inadequate for reasons we'll discuss. And so a Congress called a convention into being. That convention met. It proposed a constitution. As part of that constitution, it proposed that the Constitution go into effect if 3/4 of the states ratified the Constitution, which eventually happened, and that led to the adoption of the Constitution in 1789. Madison had to confront the issue of whether or not the Constitutional Convention had a legitimate right to propose the Constitution to the country. After all, it could have been said that under the Articles of Confederation, in order to have an amendment to the Articles, you had to have the unanimous vote of the states. And here was the Constitutional Convention saying that, well, something more than an amendment, actually proposing a new document, could be adopted by simply 3/4 of the states. Madison has a couple of arguments. One is that he says, Congress told the Constitutional Convention that you should propose a government, involving amendments to the Articles that would be adequate to the exigencies of the nation. And Madison said that the convention quickly came to the conclusion that merely amending the Articles would not have produced a government that was adequate. The only way to have a really adequate government was to do more than just amend the Articles, but to provide, in effect, a new form of government, a government that involved more than just kind of tinkering with the Articles, but really changed it in fundamental ways. So he said, we were told you have an end. Give us a government adequate to our circumstances, and here's a means, amend the Articles of Confederation. Well, if the two don't fit, if doing the means doesn't achieve the ends, which do you sacrifice? Well, your ultimate goal is to get an adequate government, so you sacrifice the means. You go beyond just amending to produce a new form of government. Still, there's a problem. You have this requirement that the Constitution goes into effect if 3/4 of the states ratify it. You're violating the amendment, the Articles of Confederation requirement of unanimity. How does Madison defend that? He actually defends it by appealing to the Declaration. And he says, basically, the Constitution doesn't go into effect. It has no standing of its own as a proposal of the Convention unless it's ratified by the people in the states. So he basically says that if the people ratify the Constitution, what they're doing is exercising their power to alter or abolish their form of government. That is, when the people of the United States ratified the Constitution in 1788 and 1789, what they were actually doing, according to Madison and the Federalist, was exercising their right to revolution, their right to alter or abolish the government, and instituting a new government, laying its foundations on such principles and organizing its powers in such forms as to them seems most likely to affect their safety and happiness. Now, one more topic with respect to the right to revolution. Going back to an issue we discussed a little bit earlier, what about this whole question of consent? How can you know if the people really want to alter or abolish their form of government? You know, how do you know if they want to exercise the right to revolution? The problem is this. If our form of government needs the consent of the governed, and if the governed is, us, people who are citizens of the United States today, have we actually ever consented to the government? Most of us are kind of born into the society. We grow up in it. We act in it. We have never really formally consented to it because we haven't had some kind of vote on the Constitution. And unless you want to have a regular vote, every generation, we'll talk about this more when we talk about the constitutional principle of constitutionalism, then you have to have some kind of doctrine of tacit consent. That is, the fact that we've lived in the country, that we've grown up, that we've participated in it, presumes that we consent to it unless we take some kind of formal action, not just to disagree with this policy or that, but to actually withdraw our consent from the whole government form itself. And how would we do that? With the doctrine of tacit consent, it seems that almost the only way you can do it is to revolt, or at least to do what the founders did in 1787, which was to propose to the people to do something radically new and to have the people in a very formal and solemn vote, such as the ratification of the Constitution, decide that they're going to alter or abolish the government. In this case, they abolished the Articles of Confederation and instituted a new government, the Constitution. But that tacit consent always kind of leaves open questions. How can we tell whether the people are unhappy enough with the government that they've actually withdrawn their consent? Of course, you can try to revolt. I don't know, grab a rifle, go down to the local U.S. Armory and attack it or something. But obviously, isolated individuals aren't going to accomplish very much. Ultimately, it's simply going to be a factual issue. Have enough people become so dissatisfied with the form of government that they act to change it, whether by bloody means or by unbloody means. And that raises interesting questions, and what I want to conclude with. And the question I'd like to leave with here is, what would it take for you to withdraw your consent to our form of government? And how would you do it? This is, I guess, a fairly abstract question, or certainly it seems very abstract to us these days, because there aren't very many of us who go to bed at night thinking, I wonder if the U.S. government is legitimate, and wake up the next morning saying, no, I don't think it's legitimate. I think we ought to get rid of it. Most of us, we don't like this or that particular part of government, but most of us are relatively happy, I think, with the overall fundamental principles of our government. But that's not true of everybody. Look around the world, and other people have had to confront the very practical issue of whether or not they should consent to the form of government they have. To take a radical case, what if you had been a German in 1933 or 35 or 37 or 39? Throughout the 1930s, the Nazis have come to power. This is a government that should be regarded as not just a bad government, it's certainly that, but as a fundamentally illegitimate government, according to the Declaration, because it denied fundamental human rights. And if that's the case, then how would you have withdrawn your consent? Because the Nazis, initially especially, went through the forms of government according to the previous German constitution, and only at a certain point in time did they transform itself into a new Reich. And in some sense, you might say the steps were technically legal as it went along. So let's say you get outvoted. You're among those Germans who get outvoted. What do you do? Well, there were some Germans who had to confront that question, and in some ways they all had to confront it, but some confronted it well and made the decision, no, this is a fundamentally illegitimate government. And so they engaged in subversive activity intended to undermine the government. Think of people like Pastor Bonhoeffer, for example. You think of the people in 1944, many of them Catholic, who attempted to blow up Hitler and to destroy the unjust regime, the illegitimate regime, that way. What would it take for Americans to think that our government is really fundamentally unjust? Of course, from one standpoint, if you were an African-American slave in 1830, you could certainly be forgiven if you thought that our form of government, the American form of government, was unjust, if it permitted slavery. Certainly, it would be pretty understandable if slaves revolted under those circumstances, although whether that at the time would actually have improved things was an open question. What about today? One kind of curious question. There's some people in this country who believe that abortion is really a fundamental denial of natural rights, that it's a fundamental denial of the right to life of the unborn. If that's the case, then since 1973 and Roe versus Wade, our government has engaged in a really fundamentally unjust policy. It's a fundamental denial of natural rights. Would it be appropriate for somebody who believed that that was a denial of natural rights to consider our government actually illegitimate, as not having legitimate power, even to engage in subversive actions against it? The big question, I guess, there is what are the paths that are still open to people to change? And one of the striking things is that in the last 40 years or so, that issue has not died. It's still a live issue, and the people who are trying to restore a greater respect for the right to life still have options open. It's very difficult with a judiciary that is filled with many people who are still defending Roe versus Wade, and still at the top level there's a narrow majority in the Supreme Court defending the legitimacy of Roe versus Wade. There are efforts in the states to try to pass incremental laws to try to undermine Roe versus Wade. And so, we could say that, the door is not closed yet. There's still a kind of open issue here. We still have the opportunity to assert our power to control the government in order to change this fundamentally immoral policy. And someone could say, it would be very legitimate for somebody who held a pro-life position not to engage in the right to revolution now, to in fact try to restore the form of government to what it was prior to Roe versus Wade, one that respected the natural right to life. Okay, with that, we've finished our survey of the self-evident principles of the Constitution, but there's a significant topic that we still have to engage in here, I think, and that is, how does this form of government differ from other forms of government? I said a number of times now that American government really was something very distinctive and new in human history, that these self-evident principles of the Declaration were really, in some ways, unprecedented in a government in human history. Now, if that's the case, we'd want to have a better understanding of why it is that we moved to this new form of government. Why did we choose these self-evident principles in contrast to other ideas about what government was about in previous forms of political philosophy? And that's what I want to turn to in the next several classes. I want to look at competing alternative conceptions of what the purpose of government is in order to bring into clearer relief the purposes of American government. So until then, thank you. Have a good day.